Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, what is portability when it comes to estate planning and elder law? Wow, portability. What does that word even mean? Well, folks, under the Tax Cut and Jobs Act, portability has to do with the second-headed monster here, which is the estate death tax, more so on the federal side, the federal estate tax. Folks, at the time of shooting of this educational video, Tax Cut and Jobs Act says this about portability. Portability doubles the estate tax exemption amount for married couples. Currently, folks, under the Tax Cut and Jobs Act, the federal estate tax right now, folks, is a whopping $11.7 million. What does that mean? If you die tomorrow, you get hit by the proverbial bus of life tomorrow, and you have an estate greater than $11.7 million, the federal estate tax will be looking to charge your estate, or more appropriately, the Internal Revenue Service will be looking to charge your estate federal estate tax. But guess what? There's a term called portability, or a concept in the tax law called portability. Portability allows a married couple to double your estate tax exemption amount. So folks, take out your calculator and multiply 11.7 million times 2. Portability allows you to double that for a married couple only. So you can get roughly like $23.5 million federal estate tax exemption for a married couple. So say Bill and Mary have a large estate and Bill passes away first. Bill's exemption amount under current tax code is 11.7 million. When his wife Mary passes away a couple of years later, Mary can use her husband Bill's unused exemption amount. They have a tax acronym for that called DSU, which stands for the deceased spouse's unused exemption amount. So say Bill has an $8 million estate in his name when he passes away, and there's roughly $3.7 million remaining of his unused exemption amount. When Mary, his spouse, dies a couple of years later, Mary's estate attorney or tax accountants can utilize her unused or her spouse Bill's unused exemption amount on her tax return to either minimize or avoid the estate tax, minimize or reduce the estate tax to the greatest degree possible. So folks, that is the portability concept when it comes to second-headed beast, is the estate death tax. Again, folks, this is currently under the current Tax Cut and Jobs Act, $11.7 million portability for a married couple. You can double that to roughly $23.5 million and utilize that Desu concept, the deceased spouse's unused exemption amount. The solution here, folks, if you are a married couple with a large estate, meet with your estate elder law attorney and ask them to put what I refer to as bypass tax credit shelter trust planning within your revocable trust, because that is permissible type of tax planning that a married couple can utilize to minimize or avoid the estate tax to the greatest degree possible. Folks, the current administration has proposed that they're looking to lower the estate tax. The proposal, from my understanding, is the current administration is looking to lower the federal estate tax to possibly $3.5 million. Will the concept of portability still exist if they do reduce the estate tax? It may not. We will certainly see as we will continue to monitor the tax code changes as we journey through the remainder of the year. Folks, if you found this video helpful, or if you want to learn additional information, please scroll down, leave a comment, post a question, or folks, go to elderlawcare.com, click on the blogs tab, click on the Elder Law Academy, because there are programs there that will teach you how to slay the metaphorical beast of estate planning and elder law. We will teach you how to have a strong shield in a sharp sword so you can slay that metaphorical beast. Folks, Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com.